Hello, everybody. Welcome to the meeting of the Federman Cybersecurity Research Center Cyber Law Program. Welcome to this meeting. Today we have the pleasure of hosting our Chief Academic Professor Yuval Shany, who will be talking about the right to human decision maker in an automatic process, about his draft article, which was sent to Forehead on the email. And I remind everybody, if you want to join our mailing list, send me an email, send me a message, and we will, of course, add you. I also want to notify that this meeting is, of course, being recorded, as Zoom as well have informed you, and that this will be uploaded to YouTube for the benefit of humanity. And with all the technicalities, and let's start our first meeting of 2024. Hopefully it'll be much better than 2023. And we will start with Professor Yuval Shany. The floor is yours.
Thank you, Gadi. I would like to share, I think I have sharing privileges, so I would share my PowerPoint presentation shortly. Thank you all for joining our activities for the year. I've volunteered to start, but we would like to engage as many as you as possible throughout the year and next year in presentations. So feel free to contact Gadi or me and indicate your interest in presenting work in progress in the broader fields of law, regulation, and technology with an online digital technology. Of course, we are also very interested in hardcore cyber security issues as well. The paper that I'm presenting is, some of you have already heard a version of it over the summer in a workshop in which a number of Federman researchers participated in the UK. Since then, it has gone a bit, I've worked a bit on it, and now I will present a more advanced version of the paper, which maybe is still following your comments. It still hasn't been published, so I'm still very receptive to hear more comments. It's a very different, I mean, it's, I'm presenting something that has nothing to do with the current situation in the Middle East. So maybe we can identify some very abstract commonalities, and maybe we can look at it as a form of intellectual destruction. So let me share my screen. As many of you know already, you all see the presentation?
Yes, we can see it.
So many of my activities in the area of law and technology and new technology in the last year or so has been undertaken in the context of an ERC grant, which looks at the different generations of human rights and offers the proposition that traditional human rights may struggle in many respects to govern some of the challenges that digital technology presents us with, and that has to do with the fact that the norms and institutions that we have in international human rights law were created to deal with, you could say, an offline environment. They were dealing with challenges that relate more to the offline world, and they also deal very much with the responsibility of states. And in the digital sphere, both of these core features, these central pillars of human rights law, offline activity and state centrism, are less relevant. Hence, there is a concern that the application of human rights law as is, without some adaptations, both on the normative and the institutional level, would generate protection gaps it would result in some human activity not enjoying the type of protection that other human activities in the offline we would want to enjoy. So the bigger project is trying to try to articulate some of these concerns, to study the phenomenon of the gap between traditional and digital human rights law, to offer some theoretic insights, and perhaps some pragmatic solutions as to how one may go forward. And the research framework is organized around an idea which stipulates that human rights law is already confronting some of these challenges. So we are not operating in on a clean slate. There are also already some interesting and important developments, which we can identify them as, roughly speaking, being divided in three categories. One is the first generation of digital rights that involves the interpretation of existing rights to accommodate the needs of the digital age. We see this very much, for instance, with the right to privacy that has been very much extended to cover many data protection and other interests that have not been dominant in the offline world, but are quite important in the online world. There is a second generation, which involves the introduction of new rights, for which we do not have close parallels in the offline world. And there may be also a third generation of digital rights, which introduces new right holders and duty holders, for instance, introducing direct human rights responsibilities for technology companies. The paper that I'm presenting today, and some of the researchers in the group are already also on this call and may reveal themselves during the Q&A. The paper that I'm presenting today is really dealing with the second cluster of rights, the idea of new rights created for the digital age. As I said, these are rights that one cannot find a close parallel to in the offline world. It doesn't mean that there is a complete disconnect between these rights and the traditional human rights in traditional human rights laws or doctrines or norms. You can find considerable overlaps, but the set of interest, the cluster of interest that is protected by these alleged new rights is not one that is easily found in the offline context. And the right that I'm focusing today is the right to a human decision maker. The idea that there are increasing calls to recognize the right to a human decision maker, or the right not to be subject to automated decision making in certain contexts, as a new digital right. And the reason why I'm focusing on that right is that probably this is one of the best candidates we have for a human right, which is hard to find parallels to in the offline world. We don't really think about this idea of a right to we haven't so far conceptualized the idea of a right to a human decision maker outside the context of computers or algorithms and digital technology. So this begs the question, and this is one of the two key questions that the paper deals with, and that is, how do new human rights emerge in international law? The other question is whether the right to a human decision maker fits the pattern in which human rights are created. Perhaps before diving in, I will say that this paper is not a normative paper, in the sense that it does not make a case for recognizing a new right to a human decision maker. Rather, it evaluates whether the way in which this right has been so far argued or justified in national and international contexts meets the pattern in which new human rights are typically introduced and justified in international law. Now, the starting point of the discussion of the first question is that we do not have a clear understanding of how new human rights come into being. And you see here on the screen, you see here two quotes which represent arguably two ends of a spectrum of approaches to the introduction of new rights. At the one hand is what you could say a declarative or highly formalistic view, positive view of the introduction of new rights, which basically says it's about recognition. Rights, new rights, rights become human rights when they are recognized as such through a political process, through a legal process, sometimes through a declaration by a court, but there has to be some formal step of recognition, and this is what we should be asking, whether such formal steps have been taken. So this is the Richard Builder approach, which says a human right is a claim is an international human rights if the UN General Assembly says so, essentially. On the other end of the spectrum, there is this more substantialist, foundationalist approach that actually looks at to try to identify some values, some interests, some structural features that would justify treating human right, new rights as a human right. And what you see here, a report from the State Department. This was an interesting project that the Trump administration embarked on, and that is to try to identify what they called unalienable rights. Was an attempt to assert that not every interest that is claimed as a human right should have the mantle of human rights. There has to be some substantive criteria that a claim has to meet in order to qualify as a human right. So this is the spectrum. It's not this part of the debate, this part of the paper that deals with new rights is not really about necessarily about technology, although some of the rights that are being asserted, some of the new rights have to do with technology. But I mean, we are seeing in international human rights law an ongoing process by which new rights are being introduced, or there are claims made for the introduction of new rights. We have just seen last year the General Assembly, which Builder mentioned, recognize a right to a clean, healthy, and sustainable environment. We have also seen in recent years assertions concerning that there is a right to the truth as a human right, that individuals have a right to know the truth about historic events that have happened. In the field of digital rights, we have heard over and beyond the question of a right to a human decision maker. We have the right to be forgotten is a very famous right that has been articulated. Some say that it's a derivative of an existing right, the right to privacy. Some say no, it should be recognized as a new, or it has been recognized as a new, an independent right. There are also claims regarding the right to access the internet. There is even a twist which says there is a right to access high-speed internet, and that should be recognized as a human right. There are attempts to recognize new right holders or new categories of right holders. So in the same way that we have rights of the child and rights of women, there are attempts now to recognize the right of youth, which is young adults, or the rights of peasants as a specific category of right holders that have encountered specific challenges. And I think when you are seeing this movement towards recognizing more and more rights, one has to be aware of the concern about right inflation. And that is the discourse about human rights and the recognition of new human rights is often raises the problem of right inflation, that if everything is a right, then nothing is a right. So if we look at rights as what Dworkin regarded rights as trumps, as interests that have enhanced protection because of their unique importance, the consequence of recognizing more and more rights is that we have more and more important values recognized, and therefore the relative importance of existing rights is becoming diluted. And in light of this sense that this is getting out of hand, and this is a very every interest group wants its interest to be recognized as a right, there are calls, increasing calls for what Philip Alston called already 40 years ago as quality control. That is to introduce standards that would enable us to pass judgment on what should be and what should not be recognized as a right. Now, what I'm not saying in this paper is what these standards should be. Again, this is not a normative paper. So I'm not saying what these rights, what these substantive criteria should look like. What I am, and I also don't have a strong view on whether we have too many rights or too few rights. This is also something which, different reasonable people can disagree about. What I'm saying in this paper is something else, and that is that although we are not able to identify in international law or in international theory substantive agreement on what are the criteria for recognizing new rights, we are able to identify a certain pattern of argumentation where those who are making the argument that a new claim should be recognized as a human right, they are following this pattern of addressing three sets of concerns: moral concerns, practical concerns, and also political concerns. And these are roughly equivalent to traditional forms, techniques of persuasion that go all the way back to the ancient Greek: the pathos, the ethos, and the logos. So the logical allusion to problem solving, the appeal to moral sentiments, which is the pathos, and the identification of the pedigree of the claim by which is associated with ethos, with the identity of those who are speaking on behalf of the rights. So this is the structure. If we go a little bit further into the structure, those three dimensions of the structure, we see on the one hand, as I said, a moral dimension. So the right is justified through moral arguments, which have to be, they're not necessarily uniform in their contents. So we are seeing different moral arguments that are being put forward by different constituencies with regard to different rights. So sometimes the claims are based on religion or on a natural law. Sometimes it's on a more Kantian notion of human dignity. Sometimes it's based on a Rawlsian notion of fairness. Sometimes it's based on Nussenbaum's capabilities approach. Sometimes it's based on urgent interests, which has been raised by other philosophers. So there is pluralism about what moral grounds are claimed, but there are almost always moral claims. By the way, this is, as you can see in the quote at the beginning of the slide, pluralism is not a new phenomenon. Already when the Universal Declaration of Human Rights was drafted, there is this nice quote by Jacques Maritain, who was a French philosopher who was involved with the process, who said, we all could agree on what rights should be on the list, but we couldn't agree why those rights should be on the list. So this, I think, actually indicates that pluralism has been very central and very common in at least in international human rights law. But even if we don't agree on what is the foundational basis of the moral claims and considerations that are put forward, it's clear that they have to deal with three dimensions which render a right to a human right. They have to deal with the idea of universality, so the claim has to somehow reflect the notion that the right in question is universal. It has to deal with inalienability. That is the idea that these rights are inherent to the human person and cannot be taken away from human beings. And it has to deal with the idea of correlative obligations, and that is that whenever you have a right, a human right, you also have a duty holder, which in our system in international law would always be the state. So you would have to not only bring forward legal moral claims for affording a right to an individual, you would also have to make moral claims and considerations for imposing a duty on a state or in a society which the state represent. Now, the one last thing I want to say about this moral pluralism is that it's not only that they are pluralistic in the sense that these arguments change depending on what speaker or what philosopher or what policymaker or lawyer we are encountering. They're also not fixed in time. So they do tend to change and to respond to changes in the world of norms, in the world of politics, in the way societies get organized, but also in the way in which technology is being put forward. So these moral claims are also dynamic. The second set of justifications that we see is the problem analysis. And that is a claim which is often supported by empirical data. And that is that if we do not recognize a certain claim as a right, then there would continue to be violations of these sets of interests or values or moral requirements that underlie this right. So if we have seen victims, states embark on practices such as enforced disappearances, there is a strong sense that in order to strengthen protection for victims of enforced disappearances, it would be very useful from a practical point of view to introduce a human right not to be disappeared, not to be subject to enforced disappearance. So we see here the use of human rights language in order to, it's based on a predictive use of the past. So the past creates certain path determinancies into the future, which if we want to change, we need to intervene through the introduction of rights. These rights also serve as symbolic repudiation of an unjust past. And often these rights are also based on certain predictions of the future that entail risk scenarios or anxieties about the future. In digital technology, we see this quite strongly, that we do have a sense that if we do not intervene, then the machines will take over, or then everyone will know everything about everyone, so facial recognition cannot be utilized, etc., etc. So the idea of risk scenarios and sometimes catastrophic risk scenarios is also a certain trajectory that we find within the problem analysis line of arguments. And the third idea is this broad political support, which is something a bit different. It doesn't really go to so much to the direct justification of a right, because if the right is justified, then the fact that others agree or disagree seems to be at some level irrelevant. but it does go when we are trying to basically get a right recognized as a political or legal matter, it does go to the feasibility of the project of recognition. So if I'm the only one in the world who thinks that the right to a human decision maker should become a human right, then the feasibility of the project of recognizing such a right is quite limited. However, if I can show that many states already have laws on the books that require human decision maker in certain contexts, and that there are many treaties that go in that direction, then I'm in a position where I have a more practical space to move forward with the act of recognition or lawmaking or creating a new right. There is also a sense that the widespread recognition is a good proxy both for the universality of the right in question and also for the persuasiveness of the moral and problem analysis arguments that are part of this analysis. So this is the structure that I maintain exists regardless of of digital rights. And you can identify aspects of this praxis in a number of very important moments in time, going from the Declaration of Independence, which talks about we hold these truths to be self-evident as a moral claim that all men are created equal. There is also a problem analysis in this declaration that governments are created in order to secure rights. And there has been a long experience in the past of abuses, and which is predictive of the future unless there is a new government that has certain safeguards for securing these rights. And there is also even then an appeal to the world community, to the supreme judge of the world, as an idea that this is the language that is used here is all men. It's not all Americans, it's all men. And there is a clear interest in conveying these rights to a world community. And we see this repeat itself in other contexts. The Universal Declaration also has these features of inherent dignity, and also the idea of the past, the catastrophic past of World War II and the events leading up to it is the reason why we should change course through adhering to rights, and that these principles have been already endorsed in the UN Charter, and therefore they have broad political support. And even when we fast forward to the most recent right that I mentioned, protection of the environment, you can see the same line of the same model kick in. The connection between protection of the environment and human well-being and enjoyment of rights, which you could say is a consequentialist argument, the allusion to damage, environmental damage and negative implications as an illustration of problem analysis, and then the fact that already 155 states have recognized the right to a healthy environment is an indication of broad political support. Now, I'm not maintaining that every new right necessarily should have these three criteria. I'm just saying that these three methods of justification are very frequent and very common in the way in which rights are being presented, introduced, and justified. Now, moving to the second part, and I'll try to be a bit quicker, and that is, does the right to a human decision maker meet this? Can it fit within this process of justification? So first, should we even be talking about such a right? I think that the answer is yes. We are seeing a right that has been already introduced as a legal right, not as a human right, but as a legal right, already in the late 1970s in France, where domestic law has prohibited that certain decisions that are based on automatic processing of personal information would be the basis of judicial decisions or of certain administrative decisions. This idea that we want to introduce certain limits on sole reliance on algorithmic decision making or computer-driven decision making in certain important decisions, or when relying on certain sensitive information. This has been picked up later by the EU directive from 1995, which is the precursor of the GDPR. And of course, we now find this in the GDPR in Article 22, in the right of that data subjects not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her, or similarly significantly affects him or her. And this is now more or less the gold standard in the articulation of the right to a human decision maker. So it's not an absolute prohibition under all circumstances, but there would be certain areas of decision making where the individual would have at least the right to object to him being decided upon without human involvement. Now, I won't go. We can do this more in the Q&A, but I will say that we do not have, even under the GDPR, we do not have a clear understanding of what is a decision that has legal effects or similarly significantly affects an individual. And the idea of what is solely a decision that is based on algorithms is also something that could be questioned, especially given what we know about automation bias and reliance by individuals on technological guidance. There is also a question of whether this is there is a prohibition, or when we talk about sensitive information, when there is a prohibition, or whether it's always a right to object, and whether we are talking whether a right to appeal would satisfy Article 22 of the GDPR. We actually have the first decision by the Court of Justice of the European Union on Article 22 issued a few weeks ago in a case involving Germany, where the court did apply this right in connection with automated processing of eligibility for financial loans, and held that a bank cannot actually outsource the decision on these issues to an algorithm, to a company that is using an algorithm to make a decision. So we know that bank loans are important, significantly affecting decisions. Now, if we would have been only within Europe, one could say, okay, it's interesting, but it's European, so it doesn't meet the broader requirement of broad political support. It doesn't seem to be universal. Maybe it's what Europeans maybe have fear of technology, or maybe they have greater attachment to privacy, because of course automated decision making implies necessarily significant data collection. So it's probably the two sides of the same coin. But what is interesting is that we are seeing a gradual expansion of this beyond just Europe. So we are seeing still within Europe, but not only the EU, the Council of Europe, we do have a modernized convention for the protection of individuals with regard to the processing of data. This is Convention 108+, which does also recognize this right. What's interesting about this convention is that it is also open to signature for countries outside Europe. And we already have a number of countries in Latin America that have joined that treaty. So it's starting to expand beyond Europe. We also have this declaration by the European Union, which reiterates the concern for the right and uses this. The reason why I'm bringing it here is, whereas the GDPR is arguably, there are questions whether the GDPR is a human rights instrument, the Declaration on Digital Rights is a human rights instrument. It's the way in which the European Union offers that the Charter on Fundamental Rights of the EU would be interpreted and applied. We have a recent convention by the African Union that follows the same standard of the GDPR. And that is interesting. It's about 9 years ago, so it's not so recent maybe, but it entered into force in the last summer. So it is, in that regard, recently ratified. We see even the privacy law of China does seem to follow in this third paragraph. You could see that there is this acknowledgement that decision-making produces, automated decision-making produces decisions with major influence. They have a right to require personal information handlers to explain the matter. And they have the right that personal information handlers make decisions solely through, not make the decisions solely through automated decision-making methods. So we do have, this is moving around. We see it in Latin America, we see it in Africa, we see it in Asia, and the White House blueprint for AI Bill of Rights also endorses this idea in the United States as an administration policy with regard to the application of digital rights in the US, recognizing a right to opt out from important decisions that are taken by algorithms. I should say that many states in the United States also have consumer protection laws that also have this idea. So we are seeing a right that appears to be spreading very fast around the world. Well, it took it some time for the French law to catch up, but since the GDPR has been negotiated and adopted, we are seeing this is becoming, like I said, a certain gold standard. When we are looking at the justifications and asking ourselves whether it meets the three-pronged structure that I've alluded to with regard to new rights, what we are seeing, and perhaps I'll go over it even more quickly now, is that we are seeing that the justifications themselves are changing over time. And that actually fits with what I said before about the dynamicism of even the moral claims and considerations, and also the relationship between justifications and changing conditions. So initially, the concern was very much about accuracy and about the superiority of human decisions. The current concerns are more about profiling, transparency, participatory rights, and even dignity interests. So the substitution of individuals for their data shadows. Now, when I try to put it, I'm going to skip in the interest of time. When I try to put it into my model, into this three-pronged structure of justifications, and ask whether the justifications that we have seen so far meet the model. So I think it's quite clear that the two first parts of the model do seem to have a good fit, in the sense that there is a lot of concern about traditional human rights issues, such as abuse of power, such as legitimacy of certain decisions, participation, dignity, accountability. These are very much traditional moral considerations that would justify restricting power. And also in terms of problem analysis, we do see a very strong concern about fast-moving technology that is generating a lot of impact, and therefore we want to introduce rights as sort of protection against individuals being run over by the technology. There's specific apprehension about using this technology, I should say, in certain contexts, such as in courts, in basically substituting human judges by machines. We've seen this already in the French law from 1978. What we have not seen so far, and that is perhaps because there has not been so far a serious attempt to take it into the global level and try to make the argument that this is a human right. We have not so far seen arguments that this is, like we have seen with regard to the right to a safe, healthy, sustainable environment, and that is that the safe and sustainable environment, and that is that many countries have laws along the lines. And that may have to do first because maybe it's too soon. The right has just been released from the into the world effectively when the GDPR was introduced into the world. It has gained this kind of attention and interest only in the last decade. And I think there is also a concern more generally about what do you do with universality of digital rights when you do have a digital divide in the background, and you do have many countries that are not really part of this story of digital technology. It is interesting that the African Union has taken this on board, which might suggest that here the digital divide problem is not as serious as one might have assumed. So in the Q&A, I mean, I'm happy to talk in the Q&A about should there be such a right? This is not the focus of my paper, but I could say, again, maybe reiterate the idea that this is a right which we do not have a good parallel in the offline world. Again, we do have some aspect, discrimination. If there is profiling and discrimination, we do have for that a remedy. If there is a problem involving dignity, this is a greater challenge because we do not have an all-encompassing right to dignity in international human rights law. If it's a question of due process in a court, we do have something to do with that. But there will be many gaps. So if we're talking about the application in the banking sector or the application in the labor sector, it's not clear whether we do have enough tools in the offline world to deal with all aspects of that right. And I think it, in a way, misses perhaps the essence of this attempted right, and that is the idea that human beings should be, in some context, being handled or being addressed by other human beings, which is something that, again, you need a machine in the picture, perhaps in order to even define to oneself the right and interests that are at stake. What I'm not making a claim here is that human decisions are better than machine decisions. I mean, we can discuss this in the Q&A. I'm not making the claim. I don't believe in this claim as a general matter. I want to emphasize that we are talking about a right of an individual to opt out in most contexts. So it's really up to the end user or the data subject to decide what to do. There may be areas where there are strong ethical concerns, such as courtroom, or maybe some saying a right to life decision in warfare, where there could be stronger limits on the application because we think it's immoral to rely on algorithms to make certain decisions, given what we know about accountability and transparency, for instance. Is it realistic to, there is also this question on which, again, I don't have a strong view. Well, I do have a view that it's not possible to have an all-encompassing right, not to use algorithms when individuals are at stake. So the claim is not that we shouldn't be using machines, it's that there should be certain limits on how, on the context in which we use machines, and maybe certain procedural rights that are assigned to individuals who are being significantly affected by the machines. So I'll stop here, and I'll be very happy to take your comments, questions.
Thank you very much, Yuval. The topic of a human decision maker is dealt with most of the time from the normative aspect, and it's very interesting to hear an analysis whether it is being constituted and built as a right in historical and in international law comparative aspect. I have a first question. I'll be moderating this Q&A part for the next 20 minutes. For the first part, let's give Daphna the right of the first question. I will take second after her.
Okay, thanks, Yuval. That was fascinating. And Oh, I see that my screen is freezing. Can you hear me?
Again,
Yes,
Okay.
you're fine.
And
maybe
as you
it's
know,
now the outside temperature that is freezing.
yeah. So I'm thinking a lot about these questions too, as you know. I have two questions. One is a question of observation, and one is a more normative question. So, did you? I mean, did you recognize a certain pattern that makes, or is there a point that a concept of protection becomes a right? What I mean is, for example, sometimes we have like concepts such as, for example, prisoners' rights, but they're not really rights in the formalistic international convention. We have only soft law documents on that, or for example, victims' rights. And in a certain way, data rights as well. I mean, they're not yet recognized in a formal international convention. So I wonder if, like, do we need a certain justification to make it from a recognized, let's say, concept to a formal right? And my other question is more of a normative question, and that, if do you think that I know, I mean, you haven't dealt with it a lot in this paper, but from what you saw, I mean, can states push for new rights morally when they are not the principal duty bearers? When we are talking about digital rights, like, do they have the moral right to do that? That's generally it.
Yeah, so on the first issue, it's a good point. We are seeing different levels of protection. So you could have a right for instance, the right to environment, which I mentioned for clean, safe, and sustainable environment. It's or clean, healthy, sustainable environment. There are different formulations. It's a General Assembly resolution. It's not a binding right. And often what we see is that first there is a declaration, which is soft law. And then there will sometimes be an attempt to formulate a treaty that becomes a hard law. And in parallel, there will be state legislation or European law that also gives it effect. And then you could also argue maybe there is some customary international law that is being formulated. So it's quite, so one could say, well, sometimes it's evolutionary. And sometimes there are limits, like you said, with regard to prisoner rights. States are only willing to accept in black letter law a very general formulation about rights of prisoners, and they're not willing to go beyond that for obvious political reasons. States don't like to give. There is no constituency for the rights of prisoners, okay? So there is no political dividend in giving more prisoner rights. So it's probably going to be stuck there forever. Now, in order to move from stage 1 to stage 2, you would most of the work you would have to do would be on the second and third justification tract. You would have to show why it is important to move, because if you don't move, that there will be no effective protection. And whether there is political support for such a move. And by the way, I would argue that the same logic would apply to interpretation. When you're trying to, by interpretation, expand an existing right, you would also have to make justifications as to why it's practically important for effective protection that we interpret the right to privacy as also applying to public to facial recognition software in the pub. And whether states, more and more states are actually signing on to this interpretation. So it's also, so it's movement not upwards in terms of hierarchy, it's a movement sidewards in terms of scope of coverage. So I think that the structure is also useful in identifying these movements. Regarding your question, I would say that yes, I mean, we are seeing, I mean, the whole business and human rights field is premised on the idea that we only have states to basically create rules for themselves, but also for third parties. That could be companies, they could be non-state actors involved in armed violence, and states are they are the only lawmaker entity that we have. And second, you could say they have some democratic or some representative pedigree that would legitimize them imposing these obligations on companies. I think there is, in terms of the from a more pragmatic point of view, and in order to get companies to sign on to this, both so they do not derail agreements within states through lobbying, legislatures, and the like, and second, that they would actually follow these norms. I think there is an interest in creating some multi-stakeholder forums in which digital rights are being considered, and we also have some examples of that. One of the comments I actually received last 2 weeks ago on the paper, I presented it in Zurich, was that I should perhaps pay more attention to these multi-stakeholder initiatives, which are another way of articulating rights, and I think it's a good comment.
Thank you. It's my turn now. I think my question is the universality of a such right. I go back to autonomous vehicles, and a vehicle may have in a near accident scenery the ability to choose whether you live or die, which I would guess it has an impact on your legal status. And I would think that this right, the creation of a right, I'm not so intentionally will say, maybe people can say, no, you don't have this right. You are harming my dignity, or whatever way you approach this, by making such a decision against me. If you decide to run me over or not. Is that intentional, unintentional? Or would you go by technically like GDPR saying, well, we'll just make a law and it will happen?
Yeah. Yeah, so GDPR, like you said, is not, like I said, also is not absolute, and there are opt-outs either through legislation or through contractual instruments. So when you talk about universality, you don't really talk about geographical universality, you're talking about sectoral universality, whether it applies in all sectors. So I think this goes to some of the ambiguity that I alluded to. I didn't allude to that ambiguity, but part of the ambiguity of the Article 22 GDPR is what is a decision, okay? Because what you are describing, yes, it is a decision that is affecting individuals, but this is not the kind of decisions I think that the drafters were mostly concerned about. You could say that the fact that you are entering an autonomous vehicle, right? Are you talking about the pedestrian, or are you talking about the driver?
The pedestrian is the better example, since he's not consensually there.
Yeah. I have to think a little bit more about this. The example that the drafters had in mind were not these kind of examples. Okay, also not with the autonomous lethal weapons. It was really about you are applying for a job, and the computer makes a decision that you would not be getting the job. So you are in a way in a situation where before that there was a human being with whom you interacted and who considered your situation, analyzed, and now it's a computer. I'm not sure that the example of driving does give you the same kind of problematic, because even if you have a human being behind the car, the human being, unless you're talking really about algorithms that would also try to guess your age and and your family status, and on that basis decide whether to run you over or steer into the pavement and run over another, which does get you a little bit in that area, okay? But if it's just a technical issue and it's not something which tries to try to understand who you are on the basis of data about you, it's a different, I think, kind of problematic. But I want to give more thought about the more complex issue, where they actually try to understand what is to make a microsecond calculation about the value of your life compared to the value of the lives of other alternative victims. So maybe if you're very old and they decide to run over you because you're old and you have only a few years to live, and then three very elderly person as opposed to one very young person, maybe this is an area where you would also try to introduce similar constraints.
Any other questions?
I have one question. First, a really fascinating topic. And I just have one question regarding the structure of the paper and the interplay between the first part and the second part. I mean, the more general part and the second part, because you started with saying that you would not like to have normative assertions in the paper. And I was wondering, since the first part is actually focusing on the development and the interpretive issues regarding the development of the emergence of human rights, so wouldn't you have to make some normative assertions in the first part in order to analyze the topic, you know, as you mean to?
Yeah, but I don't have to make myself normative assessments. I have to basically look at what normative assessments were made by those who were advocating on behalf of their rights, and then to basically catalog them actually and put them into different boxes. But I don't have to basically pass any normative judgment on whether they are good or bad arguments. So in that regard, I'm not. This is what I'm not. I'm not doing this in the first part, and I'm also not doing this in the second part. So I think it's. But I agree that it is dealing with normative issues.
Yeah, the second part is very. You know, it depends.
And the borderline between dealing with a normative issue and actually basically endorsing a normative issue can seem, I think, sometimes confusing. And I know that I've been in many, when I've presented this, the few times I've presented this, I think there was a strong concern about, okay, so what are you saying, or are you really saying this? And maybe I should try to make this point a little bit more clearer as to what I'm saying and what I'm not saying. Thank you. Good to see you also.
Yeah, good to see you.
Okay. So as it is 4 p.m., we can conclude this very interesting meeting and a very interesting presentation about how digital rights are born and whether we are seeing the birth of a new right or something else. Thank you, Yuval, and I will send out messages throughout the next days regarding the meetings of this year, update our mailing list, update the invitations. So have a great day, everybody. Keep safe.
Thank you.
Happy New Year's. Bye-bye.
Good luck.
Bye.